May I have your attention, please? The time has come for, unfortunately, the last session of this wonderful conference. I think that we have all been enjoying so much. And from justice in practice, we are switching into justice in action. So let's see how justice acts. Within this panel, we have 4 speakers, 3 in person and 1 online. Just for your information, there will be a change in the order of presentation. Professor Bieliauskaitė will deliver her presentation the last, as was her wish. So let's start from the beginning. The first presenter is our dear convener, Professor Tanasije Marinković. The topic of Professor Marinkovic's presentation is Judicial Culture After Communism. Professor Marinković, the floor is yours.
Thank you, Bojana. It's my pleasure to be able to speak at CEENJ or CEENJ. The topic of my presentation is Judicial Culture After Communism. I already evolved with respect to some initial preparations for it, so I will be focusing on one particular question, and those are the figures of judges. You'll see what it is about. First one, disclaimer in the manner of Marcel Duchamp, who said "Ceci n'est pas une pipe." This is not a PowerPoint presentation compared to everything else you have seen in this conference. All the flashy presentations you had, and I'm already embarrassed in front of my assistant Đorđe in that respect. The question I want to address is actually what is the culture, what is the way the usual patterns judges behave, how they reason when they render their judgments. And this topic, this question of judicial culture, comes in line of other approaches to the studies of judiciary and justices, which are not actually legal, but more political scientist in their nature. This interest of political, this application of political science's method to, or sociological method to legal phenomena, in particular when it comes to judiciary and judicial power, became particularly important after the Second World War. Here I list just some of the constitutions in which the constitutional courts were introduced, or judicial review of constitutionality was introduced. And this in general has helped the expansion of judicial power, and we speak in that sense of the global expansion of judicial power. This phenomenon has provoked also a vast literature on the topic. I will not dwell upon here with respect to every and each name. Let me just tell you that usually when we speak of political jurisprudence and the studies of judges from the, as I say, looking at them as political agents and looking at them in the sense of the way they decide cases and what are the consequences of their judgments in the political, so wider sense, comes already from Shapiro and his work in the second half of the 60s. Then Mauro Capelletti, who is unfortunately very often forgotten in these lists, up until modern authors and contemporary authors, Ran Hirschel is probably the most important among them. Of course, Alex Stone-Sweet, Sadurski, when it comes to the area of Central and Eastern Europe. This phenomenon has also prompted different normative theories, and we have heard some of them today. Sofia Koval was talking about Dworkin's theory of also judges and how judges should adjudicate. There is Barak. There are also those who say that we should take away constitution from the courts like Tashnet and Jeremy Waldron, who was also mentioned in another context. But this is not my angle. My angle is something which is missing in terms of the type of studies and methodological approaches, and it is missing not only in Central and Eastern Europe, but I would say wider. And that is a more structural look at how judges decide. And this is what we normally term as judicial culture. So what are the usual patterns of judicial behavior when it comes to rendering judgments? This area is heavily, as I said, under-researched. We have no clear concepts. First of all, empirically, we don't, I would say, Europe-wide and globally, we don't sufficiently look into these questions. Hence, we can't always predict how the judiciaries will evolve, how judiciaries evolve. We cannot foresee when and how some judiciaries underperform in doing their role of rendering justice. Just to give you, so we don't have these clear concepts when it comes to judicial culture. We have no typologies. I would also ask you to dwell upon the notion of legal culture, so from the political scientist perspective. We don't have, again, we can speak of different legal traditions, different legal systems, continental and common law usually, but we don't have some macro typologies. Contrary to notion of political culture, which is quite developed. And then some authors borrow concepts from the political culture, and they speak of, for example, of the authoritarian legal cultures, notably in the context of Central and Eastern Europe, of the pre-communist, of the communist period, and then we dwell upon whether they have evolved after the fall of communism or not. How much it is important, I give you just one, however, attempt to classify these things or conceptualize them. For example, a Dutch lawyer, young constitutional colleague, constitutional scholar, has distinguished, for example, the normative use of the term judicial culture when we say that someone doesn't have the judicial culture. There are some societies which do not have judicial culture, which cannot be true. There is always some kind of culture. But this shows how we have the problem with these terms. We grapple with it. Or the justificatory or explanatory use of this term when we say, oh, well, we cannot have those standards because we don't have that culture. So we use the term culture to actually justify something. Or descriptive meaning, and this is what I'm trying to do, to describe what judicial culture is. Now, it's too ambitious. I'm not going to try to look at it from the macro perspective. I will look at it from a lower level of analysis. I will try to look at the figures of judges. And these figures of judges have come as a topic for me from the previous research I was engaged with. It was a project which was very briefly about it, about judicial culture in Northern Macedonia, Albania, and Serbia. And I did it together with my dear colleagues, Denis Prešova from Skopje and Fioralba Caka from Tirana. And I think that Denis is tonight with us online. Hopefully he is. And we, for 2 years, it was a project funded by Dutch Ministry of Foreign Affairs. Matra project. We looked at 4 questions: role of judges in developing the law, judicial self-governance, so the high councils of judiciary, into the questions of how the uniform application of law is secured. And we looked at the questions of individual independence of judges. Our methodologies were primarily related to sociology and empirical sciences. So we conducted lots of interviews with judges, prosecutors, and attorneys. We also collected lots of data about the work of these judicial self-governance bodies. And soon, Aser Springer will hopefully publish our book, on judicial culture in the Western Balkans between transformation and resistance. So trying to organize all that data, I was grappling with the concepts, and then I decided to come up with some of them. So I think we can speak of 4 ideal type of judges in the Weberian sense, so as an approximation of realities, where we take some elements as that we consider as crucial. The elements, I will talk about these elements. The types of judges that I have identified are judges as judge as an instrument, judge as a bureaucrat, judge as a power, and judge as a counterpower. Of course, just like it is the case with all ideal types, there are a lot of shades within these categories. So what was the angle I was looking at? I'm still, so to say, redefining it, but I think the most appropriate criterion or criteria, because there are 3 of them, is to say that I was looking at the way the judges act, whether they act as socially responsible agents and as an independent, as a true independent governmental power who are legitimized by fair trial proceedings. So there are these 3 elements, and as you will see, the ethos of fidelity of rule of law, defined as defined by Postema, I'll say a few words about that as well, can also guide us pretty much in this differentiation of different different types of judges, figures of judges. So on one side, societal responsibility. I draw your attention to Cappelletti again. That part is completely under-researched. No one took how should I say? No one actually engaged in furthering this. Cappelletti's thought already stated in the late 70s that judges also have societal responsibility towards the whole society. And then in 2008, the Consultative Council of European Judges of the Council of Europe stated in its opinion on the quality of judicial decisions that judges do contribute to the social harmony. They ensure social harmony through rendering judgments, or they should be. Then it is important that judges are independent, but truly, I'm sorry, Zoran, for an adjective, truly governmental power. So we're not looking at the formal guarantees. They may exist, they may not exist. It is good if they exist, and we have seen that they can help, but they are not everything. Independent from illegal sources of decision-making, political or economic. I will just mention these 2 for the moment. And then whether judges empower themselves through all elements of fair trial. Milica was talking about access to the courts. There are other subjective and institutional and procedural requirements of fair trial. All of them are important for the judges to legitimize their work. I mean, it goes back to Hamilton and Federalist Papers already, that the judges have only their words to legitimize themselves. So I think that among all of those elements, it is the most important are whether the judgments are timely, well established, well argued, and whether they overall give a harmonized case law. I would like you also to dwell upon the Postema's concept of ethos of fidelity to rule of law, because Postema asks himself and ourselves, how can law produce order, provide protection against arbitrary exercise of power? And he, in that sense, insists on the ethos of fidelity. Of course, that ethos of fidelity has to be, in the first place, a guiding rule for the judges and other officials. But rightly, Postema says, and this brings us back to heart, if you allow me, here, that it is important that other members of the society remember each other of that responsibility of the ethos of fidelity to law. So he explicitly says that all of its members have to take responsibility for holding each other, and especially law officials, to account under the law. So we have to remind ourselves of the law and of the need to apply the law. So thank you, Bojana, when you remind me of those 5 minutes. Now let me go to
I know. I will try to make sure it will not be necessary.
A minute and a half until I remind you.
Okay. What are the, how I see these figures? Judge is an instrument, is a judge who lends themselves to the pressures of illegal sources of political or economics, extras, illegal sources of decision making, either in adjudication or in performing other official functions, such as, for example, in the exercise of the administrative court functions for the presence of the courts. Why do they do it? They do it because they're morally weak, so they're corrupted, or they are incompetent, so they are easily manipulable since they do not have the necessary legal knowledge. I can explain this. I'm afraid I won't have time to tell everything, so I will be very happy to go into the discussion, because all of this that I'm saying is based on the research we have done and the data that we have collected. When did they do it? Well, of course, they primarily do it in politically and economically sensitive cases. What is the consequence? The justice is not done. The judiciary doesn't perform its social function, and there is no public trust in judiciary. Of course, here you can see there are shades. So we can clearly distinguish a judge who is corrupted from a judge who is incompetent. And then that judge who is incompetent brings us to some extent to a judge as a bureaucrat. Most of the judges that we spoke with, not speaking of themselves, but speaking of the others, and I think they have an ability to reflect upon the others, so we can trust them. Actually, defined judges as functionaries, as bureaucrats. They clearly their position is that their colleagues do not see themselves as a power. Actually, it comes. It's typical for the continental Europe, but it is evolving as well. It comes from the Montesquieu's understanding, because when you really read Montesquieu and maybe not even Montesquieu's himself, but the way he was interpreted, you see that the judges see themselves actually as a part of the executive government, only not the administration which decides in the non-contentious cases. They more see themselves as a part of the executive government which decides in the contentious cases. So they, why is that so? Because they uncritically consider that the law is harmonized, there is no need for their intervention. Actually, they have a horror vacui. They're afraid of legal gaps. So there is they prefer to decide on the constitution is out of question. Now, international sources are popular or have been popular, were popular, so they're applying them to a certain extent. Milica said that we are actually decoratively citing the court of Strasbourg. They actually decide, they like to decide on the basis of bylaws. So if it can be, going down into details, thank you, to the very details, so that they don't have to think much, just the mechanical jurisprudence, and this is what they see as a right judging as well. So here we can also speak, just to then go to the next stage, also of very clear tendency toward judicial restraint, which is different from what we will see to some extent with the next type of the judge. Why is that so also, or when do they do it like that? Because to be clear, one judge can be in one type of cases an instrument, it can be also in another type of cases bureaucrat, it can be power or counterpower. So they are objectively overburdened by a huge backlog, which is also part of their responsibility and ministries of responsibility of the ministries because of the bad case law management. So it's their responsibility to some extent, but it's also responsibility of other governmental branches. And so their philosophy, so to say, their ethics is not of fidelity to rule of law, it is ethics to doing the numbers. So they're just doing the numbers. As I will not have time to dwell upon it in the last slide, so I will just say here that it is immensely responsibility of us in the faculties, because we don't actually instill a different type of model. We don't prompt our students to consider themselves as we don't actually teach ethics as a mandatory course, and we insufficiently actually prompt our students to understand that the law is discursive and not authoritarian. So there is authority of discourse and not authoritarian discourse. What they like is authoritarian discourse. They're running away from the authority of the discourse itself. So in these cases, we can say that justice is done or probably done because it is not visible. So we have, what is the outcome? The judgments are very poorly reasoned. We can see it in the case law of the European Court of Human Rights. The court will find that the judge didn't take into account the pleadings of the parties. So maybe the pleadings were, irrelevant, or maybe they were relevant, but they were not. They would not decide the case on the merits. However, the judge didn't take into account, or the judgments are not well reasoned. They're inconsistent. They're incoherent, or they're arbitrary. So these are all the qualifications of the European Court of Human Rights. Hence, the judges underperform their social function, and there is very low public trust in judiciary. Now, judge as a power is a judge who acts with the full consciousness of the societal consequences of its constitutional function as a true governmental power, again, who is legitimized by timely and reasoned case law. I think we should take fuller, I have never seen actually anyone taking fuller, except for myself, humbly speaking, fuller in the context of adjudication. And I find a lot of common points between these 8 principles, that these 4 out of 8 principles which Fuller refers to: clarity, non-contradiction, consistency of law through time, and congruence between the official action and declared rule, and the case law of the European courts when it comes to the standard prescribed by law. Now, the court doesn't refer anywhere to Fuller, but actually what court understand as prescribed by law, and sometimes the court stops short of analyzing the cases and immediately declares there is a violation if the law is not clear, if it is, or if the case law is contradictory. So not just the legislative sources, but case law as well of the given state. If it is not clear, if it is not harmonized, I think we can take these. They gave us a relatively solid ground, although it is also a question of debate. What we mean by no contradictions, etc., etc. Nevertheless, I will continue. These judges, they embrace the appropriate working ethics of fidelity to rule of law, and they're competent to defend it. This is very important. Not just that they're ethical, but they have the competence, legal knowledge to defend it. We have, for example, studying professional preferences of the students of Faculty of Law, this one, which is prestigious in Serbia, of the 4th year. We have discovered that students, not with the with the average mark, which is 10 or 9 or 8, but of 7 plus, prefer to work as attorneys. They would rather go to the business as lawyers or work in administration than to be judges and prosecutors. So we basically have bad students as judges and prosecutors, and we are, unfortunately, we are not taking into account, not only that we are not taking here into account, Council of Europe doesn't take into account. Council of Europe doesn't care that none of these countries have, for example, European human rights law as a mandatory course. We have it as a optional course, not just in Serbia, in former Yugoslavia, in Central and Eastern European countries that I have studied. Contrary to the old democracies, they have it and they study it already in the 1st, 2nd year. And they embrace the philosophy of the European Court of Human Rights. They embrace the methodology. Thank you, Alfred. So justice is done and it is visible. Separation of powers is respected, and there is high public trust in the judiciary. And I finish with the final type that is a judge as a counterpower. That is a type of the judge that we have seen recently. The judge who actually goes out of the courtroom because there has been a breakdown of the constitutional system of separation of powers. So judges cannot just stay in the courtrooms and pretend that this is not relevant to them. Judges have been engaged in this arena, which is purely political. And we have seen this in Serbia, we have seen this in Turkey, with differing effects, but Turkey is also taken as an example. Poland as well, and we will have in just a few minutes Tadeusz, who will tell us more about Polish case. So we have judges who go into the streets. It is part of their social responsibility. It is part of their ethos. If there is ethos to rule of law fidelity, then they have to do it, because they're also fueled. Their reactions are fueled by the populist attacks on them. And they do exist, my dear colleagues, they do exist populist attacks on the judiciary. Now, whether the judges, and I will finish, will protect themselves, it depends on their engagement. It depends on the engagement of the judges' associations. We have seen these kind of positive actions and negative actions in Serbia. We have seen the engagement of international bar and judges' associations, such as MEDEL, and their representatives speak of, for example, Serbian, Turkish, Polish cases as they take them as case studies. So society has to stand up, and this is where Postema's ethos of fidelity comes into the focus again, because the society has to stand up to protect the judges. If they don't stand up, if they don't mobilize sufficiently, and I finish, this is what we call the judicial support network. Judges have to be the first one, or among the first one, to take the floor. But we academics, civic society, and then international non-governmental organizations, they also have to engage in this process. And if they do, if they mobilize sufficiently, there is a possibility that the separation of powers will be restored. Thank you for your attention.
Thank you, Tanasije, for raising so many important issues. It appears that there is really a huge role of the law faculties in that regard, and we should think about that. The legal ethics course that you mentioned, but also legal clinics and the problem with the law and free legal aid, which actually does not recognize law faculties as providers of free legal aid. But let's continue in the discussion part. We are actually continuing in the same manner and within the same topic. Our next speaker is Professor Tadeusz Zembrzuski from the University of Warsaw in Poland. And the topic of Professor Zembrzuski's presentation is the crisis of the judiciary system in Poland, searching for solutions or stagnation in jurisprudence. Professor Zembrzuski, I will now give you the role of presenter so that you can share your presentation with us. You should be able to do it now.
Okay, thank you very much. I will try to share my presentation. Okay, please let me know. Can you see my presentation?
Excellent, excellent. We see it. Thank you.
Okay, thank you very much. Well, first of all, it's a great pleasure for me to present you my topic. First of all, I have to also apologize that I'm only online. It was impossible for me to arrive this time to Belgrade. We had an important anniversary by the university, so I had to stay home. But I believe that next time we'll meet in person and discuss. Well, yes, both papers are connected because the previous speaker showed us the very interesting macro perspective, and I will try to show you a concrete example of the judicial crisis. And two keywords of my speech will be warning and hope.
Excuse me for interrupting you, but we have trouble hearing you. Can you maybe fine-tune the audio or try to do something?
Well, what can I do? Maybe I will try to stop my presentation and I'll do it once more. No?
doesn't. It's
Can
not
you hear
connected
me
to that.
properly or not? Not very good.
There's just some reverberation and we're trying to fix it, but our microphones are off, so it shouldn't be on ours.
Now I try to change the speaker. Is it better now or worse?
Well, the same.
The same. Well, I had some connection problems, but I hope it will work. Maybe I will try to speak louder. Can you hear me in the moment or?
Yes.
Yeah, we can, but yeah, it's not perfect. I mean, other online speakers, we really did not experience this kind of problem. It must be something on your side, but it's understandable.
I hear him correctly.
Yeah, Isabel, we hear you perfectly. We've been able to do that during the 2 days. This is something with Professor Zembrzuski's computer, I suppose.
Okay, I will try to do my best. If it will not work, please let me know. I hope it's a connection problem. I'll do my best.
Okay.
I hope you can see it once again, my presentation.
Yeah, we can see that. Thank you.
Okay, so let me start. I would like to tell you about the crisis of the judiciary system in Poland. I will try to show you, I think, quite interesting example. First of all, I would start with the sentence that Europe and European countries extract many benefits arising from an order based on specific rules. Our tradition, system, and history are different, maybe very different, but most countries created common principles that can be understood for citizens. For example, we can indicate the European Union's legal order. This order is created as the so-called union of values founded on respect for human dignity, freedom, democracy, human rights, and the rule of law. Well, I'm sure that all these values are based on shared roots, giving rise to obligations addressing all member states. The importance of respect for the rule of law in every country, in every continent, ought to be the focus of attention and care. You may say that it sounds obviously, but why it is so important, and also so important in my case? Because once a country loses its attribute of legality, all these values are undermined, turning into meaningless slogans and postulates. Democracy and its jurisprudence may collapse in such situation. I would like to shed light on the legal situation in Poland, in my country, a country which has in recent 8 years been exposed to a rule of law crisis. A Central European country with the population of nearly 38 million people had been affected by a crisis of state's government and political system. During 2015 and 2023, many controversial actions were taken by individual centers of power by a ruling party which had law and justice in its name. But in fact, everything was the opposite, because there was no law and no justice as well. They brought a profound constitutional crunch. We experienced that the instrumental abuse of provisions underlying the state's government and political system, breaching standards and rules of interpreting the constitution, brought modifications to the state's governments and political system without any amendments to the basic law. What could we see? Well, the main problem was with the division of power, because it was seriously distorted. The safeguards of the judiciary's independence was weakened. Poland had in recent 8 years been challenging fundamental values and principles like the rule of law, loyal cooperation, and the primacy of applying EU law. Well, I'm sure that most of you have heard a little about the situation in my country, about this abusive constitutionality expressed in negligence of the rules and principles of law. Well, the crisis produced major repercussions in the European Union and international relations. It was a special kind of depreciation of international agreements and obligations binding on my country. Polish relations with our neighbors, other countries, and especially the European Union as well, became worse and worse. The instrumental abuse of provisions underlying the state's government and political system and destruction of international relations were connected with efforts to antagonize the public, omnipresent propaganda, pressure, hate speech, and harassment. Well, Poland was very popular in negative meaning in Europe. Well, you can see that many judgments of the Court of Justice of the European Union and the European Court of Human Rights have referenced multiple legal issues in Poland on a few occasions over recent years. Here we can see the most important judgments of the Court of Justice of the European Union, but not only this court. Here on the next one you can see also many European Court of Human Rights judgments about Poland and Polish problems during these years. So we had many judgments, but Polish authorities went as far to challenge the authority of these courts, of the Court of Justice of the European Union and the European Court of Human Rights. Statements by domestic courts, the Supreme Court and the Supreme Administrative Court, have been profuse as well. So such attitudes destroyed Poland's position and authority as a member state of the international community. What was the biggest problem? Well, connected to our topic, it was the influence on the judiciary. Well, it negated the very notion of democratic states, turning it into something closely resembling a caricature. The Polish judiciary is an area which had suffered the biggest devolution and problems. Why? Well, because legislative changes in Poland during these years have been intended to challenge the independence of the judiciary. So this is the main problem. We had the political control of the judiciary and prosecution services. It was possible to penalize judges for rulings designed to implement European standards or even to implement international courts case law. The government had the capacity to influence the adjudication of individual justices. We had a very big, and still we have a big problem with National Council of the Judiciary. It's Krajowa Rada Sądownictwa in Polish. Why? Because most lawyers in Poland, and not only in Poland, we believe that the council's composition contradicts Constitution of the Republic of Poland. Why? Because judges of this council they are selected by representatives of political parties rather than the judicial community. In consequence, the Council is recognized as a body differing from the one referred in the Constitution of the Republic of Poland. Why it is so important? Because this situation impacted the capacity for proposing independent and impartial candidates for judicial positions in Polish courts of law, giving rise to a grave, I would say, systemic flaw. This problem is very big because the issue currently applies to as many about more than 3,000 judges on all levels in the judiciary. They are called neo-judges, new type of judge in Poland. Well, so you can say that the situation in Poland was very bad and hopeless, as I try to show you the most important problems. So what kind of change have we seen? What is its significance? Well, it has to be mentioned that we have seen that the restoring of democracy in the middle of Europe, in the EU country, and restoring the rule of law is still possible in 21st century, because in Poland's parliamentary elections of October 2023, so last year, brought a change in the government and a new parliamentary majority. So from this point, we have started the process of restoring the rule of law and remedying the judiciary. It is obvious that the rule of law cannot be rebuilt on unlawfulness or restored with the use of methods potentially triggering doubts and controversies. So it is not easy, and I have to say that we have still a lot to do. It requires time and many difficult decisions. The effort to restore rule of law in my country is a multi-stage, complex, and time-consuming task. Why it is important to see the European context? Because restoring process would be impossible, in my opinion, if we would have to stay alone in international relationship and international system of judiciary. So I would like to tell you that why the European community and European Union as well took such an important place in the restoring process. It has to be said that the European values are very important for us. That's why the reaction of European courts was very important for the changes which have happened and still are waiting for us. Why? Because many conclusions may be useful guidelines to the restitution of and strengthening the rule of law. Let me just show you just two examples. First one, here you have the Court of Justice of the European Union, and this judgment you can see on the presentation. Well, the judgment is one of the most important, most significant rulings. Why? Because it was said that the National Council of the Judiciary in Poland is not independent from the legislative and executive powers, impacting the Council's capacity for proposing candidates for judges. It was said that we do not have an independent or impartial court as required by European Union law. So this lays down a premise for systemic changes for the Polish judiciary. And the second example was the European Court of Human Rights judgment in case of Lech Wałęsa versus Poland. This judgment should also play an important role in restoring the rule of law in my country, because this judgment tells us a lot about the violation of the convention and systemic problems which grow in Poland, but they also can happen in every European country, in every country in the world. Well, this attention was drawn to the need to amend the National Council of the Judicial Law, so we can read a lot about judicial appointment procedure and how to find any solution. So you may ask, is the rule of law already restored? You can ask, does the crisis belongs to the past? So, truly, the answer is no, not yet. Almost after a year, we can see the shortage of swift and radical solutions. The average citizen cannot count on rapid or radical unexpected changes. Wow, why is the situation not optimistic still? We are still waiting to have our system restored. Well, Poland is facing the need to repeal former and create new regulations conforming to the spirit of the rule of law and other values which are important for European Union member states family. Rebuilding public trust also remains priority. Well, so why it's not changed already? Because we are trying to do it, but during many meetings with the legal community in Poland, the current authorities discussed about projects concerning three issues. First one is about so-called neo-judges. The second one about the National Council of the Judiciary, and this last, the Supreme Court of Poland, the most important court in the country. It goes without saying that the process of restoring the rule of law will be a lengthy one. Why? Because we still have the problem, because we have to wait another year for specific actions until the next presidential election, because the current president, who is still a member of the previous political system, he will block any attempts to repair the rule of law. So we are still waiting, and we have to wait for the new one after next election, and then we would start repairing the system. So we can say that we have lost 1 year, but we still hope that it would change. So let me get a conclusion coming to the end. Well, what I have to say that the rule of law is the universal meter for how democracy operates, the one which ought to apply to all European Union member states and other countries for review and performance assessment purpose. And the last sentence in conclusion, that the situation in Poland should be a warning to other countries against the risk of destroying the rank of the rule of law, because it is quite easy to destroy it. And we have seen it was very easy to destroy it. And now we see that it is much more difficult to restore it. But we still have the hope. Thank you very much. I believe that the connection was good enough and you can have the further review. Thank you very much.
Thank you, Professor Zembrzuski. As is always the case in life, it's easy to destroy something, but it needs plenty of time and effort to restore it and to come to zero position. You were talking about difficult decisions that are ahead of you, and I'm sure that during the discussion phase of this session, we can hear about them as well. The next speaker is our teaching assistant here at the Faculty of Law, University of Belgrade, Đorđe Marković. The topic of his presentation is quite a long one: resurrection of old legal acts, determination of decision-making standard, and the responsibility of constitutional courts, Serbian constitutional court in action. But actually it's about one decision of the Serbian Constitutional Court, and I'm looking forward to hearing Đorđe's argument about the decision. Đorđe, the floor is yours, and I will share the presentation immediately.
Thank you. It's my big pleasure and honor to participate in this great scientific conference today. And when it comes to the social harmony, we came to one of the recent decisions of our Constitutional Court, and we will see why I think this decision will become famous in the future, also not just in this moment particularly. Okay, as you can see, welcome to the Serbia on a western. Okay, sorry. Okay, never mind. On the left side on the map of Serbia, sorry, this pink color, it's a Jadar Valley. This is how it looks in a bigger map. Why it's famous? It's famous agriculturing area, and it's rich in water, and furthermore, it's important from historical perspective for Serbian as well for European history, because one of the first Allies victory took place here on nearby mountain Cer. In First World War. Thank you. That's like, as you can see, it's a very nice landscape, and very rich in from the various perspectives. Also, unfortunately, it's also rich in jadarite mineral. This is a combination of several. This mineral is a combination of several elements, and as you can see at the end of the picture, of the photo, and especially lithium is important. As you know, nowadays we need lithium-ion batteries for especially for electric vehicles. And here the story begins. The actors of this case, or of this drama, is government. At the first place, government of Serbia. In the second place, citizens of Serbia, and our Constitutional Court. The chronology of events, the most important, actually, just to say, like 20 years ago, the first research actions was done in this area of Jadar Valley, and jadarite mineral was found in, I think, to 2004. And 4 years ago was the beginning of the process of the mining preparation process. And first, the other regulation, which is important for our case today. The full name is the Regulation on Establishing the Special Plan of the Special Purpose Area for the Realization of the Project for the Exploitation and Processing of Jadarite Mineral Jadar. And for obvious reasons, I will call it first Jadar regulation. In the next year, there in Serbia, our citizens organized a huge protests against this regulation and against mining in this area of Jadar Valley. And at the beginning, at the end of that protest, and at the beginning of the year of 2022, our government adopted the second Jadar regulation, and that regulation dismissed or banned any process of excavation of this mineral. And our government said that the story is end. But, plot twist, sorry, here it is. This summer, in July 11th, our Constitutional Court made a decision, I will call it Jadar decision, adopted Jadar decision, and voided the second Jadar regulation. And the story started again. And the third Jadar regulation was adopted, and actually it's like resurrection of first Jadar regulation. It's like just the same as first Jadar regulation. You will see a few slides later how it looks like. Okay, I think that this was important to have like whole story in your heads, in your mind, how everything happened and where are we now. Okay, why this particular decision of Constitutional Court is controversial? As I said, in this decision, our Constitutional Court voided the second Jadar regulation, and the reasoning behind this decision is very dubious. Formally, our Constitutional Court examined the second Jadar regulation like in total from material aspects, but substantially our Constitutional Court just examined the adoption process, bless you, just adoption process of this regulation, like just formal perspective of this regulation. And also we have one dissenting opinion regarding to this decision and one concurring opinion. The core of the reasoning of this decision, I will quote it as the principle of the rule of law from Article 3 of the Constitution of the Republic of Serbia is one of the basic principles on which the constitutional order of the Republic of Serbia rests. The Constitutional Court assessed that the contested regulation was not adopted in a manner that is in accordance with the provision of Article 3 of the Constitution and the provisions of the law on a government and law on environmental impact assessment. Here is important like to bear in mind the violation of principle of rule of law, and secondly, on the same page, Constitutional Court stated that this is because it follows from the explanation of the proposal for the regulation itself that the only and exclusive reason for its adoption is continuous harassment of citizens, which according to the Constitutional Court must have been important for the government's decision on the further fate of the project, but in this case the negative opinion of the interest public could only be evaluated in the procedure and in the manner prescribed by the law on environmental impact assessment. Therefore, the Constitutional Court finds that the government exceeded the limits of its jurisdiction by passing the disputed regulation. And now we will first take a look of this, how our Constitutional Court examined the violation of the rule of law of the Article 3 of Constitution of Serbia. Just a second. Okay, like the title of this slide is Determination of Decision-Making Standard, Rule of Law. And according to Kelsen's terminology, rule of law can be classified or qualified as ambiguous word. We need some effort. We have to do some effort to precise it, to define it. And Kelsen wrote almost 100 years ago that if the Constitution makes the demand that the legislator unfold his activity in harmony with justice, freedom, equity, decency, and so forth, one might be tempted to regard these words as guidelines for the content of future statutes. And also, Kelsen stated that the possibility is therefore not at all excluded that the Constitutional Court, if called upon to decide on the question of the constitutionality of a certain statute, might annul that statute on the ground that is unjust, while claiming that justice is to be regarded as a constitutional principle that ought to be applied by the Constitutional Court. This, however, would concede to the Constitutional Court a fullness of power that must be regarded as altogether intolerable. And you can see some parallel with between this term of justice and our term of rule of law. Like our Constitutional Court completely failed to precise and to define rule of law, but call it in this case and said this regulation is not according to constitution, it's not according to rule of law, to one ambiguous term, but he didn't say what does he how it understand this term from its perspective. And at least our Constitutional Court have tried to precise this term to have clear determination, clear decision-making standard, but he failed to do that. When it comes to the object of control, as we wrote and as I said, our Constitutional Court just examined this regulation from the formal perspective. Just the adoption process was controlled. And the Constitutional Court stated that the government violated the constitutional principle of the rule of law because the only ratio for adopting the second Yada regulation was the prolonged harassment of citizens. And maybe the most interesting thing is where the Constitutional Court found this prolonged harassment of citizens, this ratio. It found it in a governmental explanation of the draft of second Yada regulation. And as you, yeah, exactly, thank you. And as you know, usually the object of constitutional control is a legal act in a force. Sometimes there are some exceptions that it can be like some previous legal act, but this is very, very interesting. This can be some ground to Constitutional Court can make some reference to this explanation from the draft, but not like to put the main accent of this part of governmental action. And why it's this highly problematic? Because in this process, our Constitutional Court violated several articles of its own rules of procedure. In the first place, and this is also connected to the act of Constitutional Court. The Constitutional Court found that legal situation is fully defined and the collected data provide a reliable basis for decision making, and consequently he applied the exceptional and shorter procedure of examination of this regulation. As everything was clear and there was no doubt about this situation, and it wasn't like that. On the second place, the Constitutional Court did not ask our government for its opinion regarding to this regulation, and this is a well-established practice, and it's contrary to Article 46 of its own rules of procedure. On third place, from the dissenting opinion, we found that even judges in a court didn't know how the proposal of regulation came to the court. And you can see here, you can read the statement of one judge in his dissenting opinion. It is significant that in the case files, there is the draft of the regulation with an explanation, even though it is otherwise impossible to see in what concrete way the Constitutional Court came to that document. There is no usual letter addressed to the author of the act in the files. and thank you. On the fourth place, Constitutional Court applied the second exceptional procedure, referring to the Article 37 of the Act of Constitutional Court to avoid conducting the institute of public hearing. As you know, public hearing is usual procedure, especially in cases like this, in a normative control, in abstract process, but our Constitutional Court thought that it's not necessary. And finally, pretty comic situation. You can see that our Constitutional Court decided on July 11, and just tomorrow, day after, on the July 12th, the decision was published. What does it mean? That decision was made, for example, in Monday, and till Tuesday, they made decision-making process, decision writing, dissenting writing, and they merged all of these materials and sent to the publisher of our official Gazeta. Everything in less than 48 hours, between 24 and 28 hours. And we can ask old question, who controls the Guardian? As you see, Constitutional Court violated its own rules of procedure, even the one article of its Act of Constitutional Court, and undermined the abstractness of process. Okay, thank you. Process of normative control, and brought it closer to the process of constitutional complaint. And this raises the old question, who controls the guardian of constitution, and to whom the constitutional judges are responsible to their misconduct. I'm afraid to say that there is no legal or political sanction yet. We will see maybe, and I'm calling you to propose maybe some sanction, at least in theory. Okay, what is the epilogue of this story? The resurrection of the old act. One of the best elements of this decision was this part. In particular, the Constitutional Court additionally points out that this decision does not revive the previously adopted regulation, first Yada regulation. While the decision does not encroach on the constitutional authority, the right and duty of government to determine and conduct policy, etc. And this is according to Kelsen theory that legal act that existed before the annual statute shall not be entered into force automatically after the cassation of statute. And as you can see, Kelsen stated that it should be wise to leave it to discretion of the Constitutional Court to decide in which cases the previous acts can be like resurrected or not, from the situation to situation. Despite this clear Constitutional Court instruction, our government just a couple of days later adopted the third Yadar regulation. As you can see, I will show you here. This is the whole regulation. This is the title of regulation. This is the resurrection provision, and this is the transitional provision. That's all. And you see, it's clear that government resurrect the first Yadar regulation, a contrary or completely contrary to the clear Constitutional Court instruction, and this also pop up the question about possible violation of constitutional principle of the binding effects of Constitutional Court decisions according to our Constitution. Okay, and there are several dilemmas, and this is the final slide. In 2021, there was several initiatives raised before the Constitutional Court, which call it to examine the constitutionality of first Yadar regulation. But the Constitutional Court have never done that. And the question is now whether all these initiatives are alive again if the first Yadar regulation is alive again. And second question, what's going on with the several acts of lower legal force which were adopted in previous years? Also, whether they are in the legal force again. And finally, the Constitutional Court had opportunity and has a legal opportunity possibility to initiate the process of examination of the third Yadar regulation, but till now he failed to do that. And this is the end of the story till now. We will see what will happen in the future. Thank you for your attention.
Thank you, Đorđe. I think that you offered many valid arguments to confirm the conviction that I had even before listening to you, that actually this was the abuse of the rule of law by the Constitutional Court of Serbia. Thank you. Our final speaker is Professor Jolanta Bieliauskaitė from Kazimieras Simonavičius University in Vilnius, Lithuania. The topic of the presentation is jurisprudence and changing landscape of legal professions. Professor, you have the floor. I will, of course, share in a second.
Thank you. Thank you for perfect pronunciation of my surname and of Kazimieras Simonavičius, the university name. Very good result. Good evening, everyone. And so I'm Jolanta. And so what about you? How are you doing today? Good. Do you remember how the day has started? Yes. How? So most probably, I believe the start of the day was impressive because we have opportunity to hear a brilliant, I should say, a very insightful and emotional even presentation delivered by Professor Sara. And yes, we started the day with the legal tech session, at least the session related to legal tech. And legal tech is unescapable, I should say, recently, and therefore, again, I will talk a bit about that as well. So Claudio talked about the engine of datafication, and here you can see the engine as well, but this is, in this case, the engine of the aircraft. Because engine, for me at least, also could symbolize the progress. And yet, I believe that as the pilot, which is capable and necessary of steering the aircraft, yeah, we all fly, we came here by plane most probably, yes, and even though aircrafts are very automatized, if I pronounce correctly, we still need a human being, the pilot, to steer it. So, and I think that human being is responsible and capable to steer the direction of the progress so far that the aircraft of humanity would not crash. And so, how we, okay, let's try. Oh, yeah, thank you. So, how we as researchers and lecturers of jurisprudence could contribute here, and I will not read the text because you have opportunity to read it in the abstract. So, have you already met these guys or ladies? Yeah, future legal professionals. Yes. Even though if you think that you haven't, I believe you did, because most probably you have taught them or you are teaching them right now. And therefore, I'm not sure how, if it does make sense now in the very late evening to describe each of them. But actually, this list of future professionals was inspired and found in CEENJ, most probably. I don't know if I pronounced correctly the surname. The book about future legal professions. But the future is already here because some famous providers of legal services, they also already are talking and writing about these legal professions. And also with the rise of artificial intelligence and its rapid development, we should also emphasize AI and related legal professions, and so on and so forth. By the way, personally, I've just met on Thursday the person who is just like providing legal services, but she's also, I should say, legal design thinker. Also very interesting. So, and these people need our help. Why do I say so? Actually, why I'm late, because I came just yesterday afternoon, and we had a practical conference on application of artificial intelligence in law and business on Thursday in Vilnius. And I received, after my presentation on competences, I received the question from the Minister of Justice, who was also attending the conference. And he asked, like, how to identify that AI system that, for instance, is just now being created is one of the unacceptable risks. And this is a very tough question, actually. And I was thinking, okay, very interesting, but of course, it's impossible to regulate the things that are not being created yet. Yeah, in general, it is complicated to regulate something. Yeah, as you can see, you can regulate, but then you just don't follow your regulations. So therefore, I was happy to be a student of philosophy, and now I have a time to research of philosophy of law, and I referred to philosophy, and particularly to the deontological ethics of Immanuel Kant. So this means that studies of jurisprudence matter more than ever now. Why? Well, basically because of the competence we are trying to develop and train in our students. So there are no doubt that the jurisprudence gives contextual understanding of law. It also encourages development of intellectual curiosity, and this conference is just an example of this, and prepares ourselves and our students for legal innovation by helping lawyers anticipate future changes in law, especially as technology, globalization, and societal shifts challenge traditional legal frameworks. So with the rise of technologies, and especially generative AI, other competences developed by jurisprudence studies got extremely important for professional readiness of future lawyers. And you can see some of those competences, and we have already been talking about them, about, for instance, critical thinking and analytical skills. How do we develop them in our students? And I remember the presentation of Professor Olsay from Çukurova University in Turkey. And I believe that Stefan, Vasilis, and Konstantinos, and others also are focused during their presentations and lectures on developing of ethical reasoning and moral judgment. So there's nothing new. Most probably I will explain to you. Of course, adaptability and capability to adapt to legal evolution is also very important these days, and therefore jurisprudence is also focusing, and jurisprudence provides the flexibility to adapt to new legal paradigms, and not only to adapt, but to know that there are a lot of different legal paradigms, because sometimes they say that, oh, it's only legal positivism, but no. So even though some of you now and a lot of students usually during lectures are looking at their mobile phones or computers and don't communicate, but actually the communication skills are very important, and communication and collaboration. Even with artificial intelligence, we communicate. We say, hi, could you please do something for us, at least in some cases. And of course, interdisciplinary integration, because jurisprudence often intersects with other disciplines like politics, as we can see, sociology, economics, and now, of course, technology. So following Tanasie's presentation, we should say that these competences are relevant not only for future legal professions, but also for current classical legal professions like judges, prosecutors, attorneys, and so on. So this is a formal conclusion, but of course, just to emphasize that I believe that we all agree that jurisprudence contributes to the advancement and resilience of the legal profession as a whole. And next question would be how to develop these skills and what are the methodologies. And I would like to kindly invite you to share your experience in the next CEENJ conference in Vilnius. And thank you so much, Jasminka, Tanasie, and all the team of Faculty of Law of Belgrade University for really perfect organization and very high standards set for future conferences. Thank you all.
Thank you, Professor, first of all, for inviting us to Vilnius next year. But besides that, for your very inspiring presentation, I think that our students are actually more aware of that need and problem than we are. And I can tell that from our experience here at the Faculty of Law. This year, we introduced a completely new legal clinic on law and technology. And I can tell you that even though this is the first generation of students, it was among the most popular. So we had many applications coming from students, meaning that students are aware of the needs that you were talking about. The floor is now open for questions and comments, and I can see that there are many. Let's start with Mina. I first saw Mina's hand.
Thank you. I have two questions for Professor Tanasije, actually. First, I wanted to ask you, like, when you talked about judge as a power and counterpower, I think that you maybe were inspired in some sense by Dworkin and his Hercules. And I have a problem with how Dworkin describes the judge, because in a sense of, I think that many of theorists, he among them, who talk about judges and their power and how judges should be and the standard of what judge should be held, they do not explain or explain at all how that standard can be acquired in practice, because I think that they also say that many judges are either corrupted or they don't have enough power to stand for some opinions. But how can, if we start at the law faculties, how can we have that standard in practice? And the other question is, when you said, like, that's, I think, more of an observation. When you talked about corrupted judges, you mentioned that they are like not morally on some standard. I wanted to ask you why maybe it's better to just say corrupted and not moral, because I think that, and Dworkin also says that in some of his articles, I think that when we say that something is moral or immoral, that we perceive that differently, and that those standards that we think of what is moral, in a sense, that they're highly subjective and not objective. And even Dworkin, when he tried to explain that, he said that basically, well, if you don't have any good reason to believe that something is not objective, then you should believe that it is objective and not subjective. So I think that maybe that's problematic when we perceive like what is moral and not.
Professor Okočić.
Thank you very much. Tasso, you mentioned my name, so you actually deserve everything that you're gonna get, but we're getting tired, so I'm gonna restrain myself to 2 points. First is to provisionally diagnose you. So what seems to me to be the case is that you're captive of an ideology which has 2 prongs. It would be tempting to call it constitutionalism, but it's more complex than that. The first constitutionalist part is actually the thoroughly parochially American philosophy of good government, which fetishizes the separation of powers for a contingent set of historical reasons, which we cannot get into now. And over the course of history, not unequivocally, by the way, because you have throughout the 20th century, American theorists railing against the black robe aristocracy. I hope you're familiar with the term. So the first prong is the American ideology of good government. We are all like fish in an aquarium. We're swimming in it because we are ruled by the United States. And I mean, it's that simple. The second prong has to do with the vestiges and history of parliamentarism and the development of parliamentarism in the 19th century, where the modern parliamentary government developed in contradistinction and in fights against the monarchs and aristocracy. So the provisional victories and compromises were coded and interpreted as the balances between the executive and the legislature and pouvoir neutre, etc., etc. So that's by far not the only interpretation of parliamentarism, but it kind of still resonates and buttresses this idea of branches having their own separate dignity instead. And here I come to constructive analytical question, realizing that at the end of the day, I'm assuming that that's the case, we're talking about the functions of government in its totality, the functions about the state in its totality. Now the question is, what is the difference between the two? And here is my pointed analytical question. So question number 1, part 1. Is judiciary a branch of government in any trivial, literal sense of the word, or it's just a label we've inherited. Or if you wanted to put it differently, is the judiciary or the courts, are they the organs of the state, institutions of the state? Second question, are there, I'm assuming that the answer is yes, but I have to ask it, are there the functions of the government and of the states that transcend the protection, that include, but that transcend the protection of individual and collective rights? So if the answer to the first question is yes, and the answer to the second question is yes, then the question is, how do we think about the role and function and proper position of courts and those who occupy positions within them, given the fact that that judiciary and courts must, at the end of the day, serve the functions, purposes of state and the government? And if that's the case, is the verbiage and the vocabulary we've inherited about their rights and the balances really the most illuminating, practical, efficient way of talking about it? There.
Thank you. Alexa.
Thank you all once again for these great presentations. I'm so tired, so I will ask only my friend Tadeusz one question. And that question is, do you think that the ratification of Protocol number 16 to the European Convention of Human Rights can partially solve the crisis of judiciary in Poland? So that's it. Thank you.
Thank you. Yeah, I see Isabel's hand, but let's collect first the questions here in the room.
I cannot resist to ask my question to Professor Marković as well, because I think we all have very common issues to solve. So we all think about the role of judiciary and how they are going to solve cases, to solve disputes, and we are not satisfied of their mere technical role of applying formally the law. That's why we are searching for something new. And you referred, as far as I understood, you are supporting the idea that the judges should be more active. Even you supported that they have to be politically active and express their position. But in fact, I think there is a risk. And if the judges are populists, and we allow them to make their decisions, including and also involving their political affiliations, where can we reach? Thank you.
Thank you.
I'm curious about the topic of the four figures of judges. From a sociological point of view, did you find a way of distinguishing the different figures through the way they motivate their decision?
Professor Boutzakis, you wanted to ask something?
Just a question for Professor Marković. You referred to the ethos of fidelity. Going back to Professor Osterman, would you propose a similar classification that's proposed concerning the judges, concerning lawyers? Because I guess the idea of having this ethos must be rooted into the mentality of lawyers also. Thank you.
Thank you. Milica, please.
Okay, thank you. I skipped the beginning of Professor Marković's presentation, so I just have a question. If we know at least informally who submitted the initiatives for the review of constitutionality of the other regulations, and just to share my thoughts, very short experience which I had at the Judicial Academy, because I taught several courses in human rights there. I gained very strong impression that there's some later generations of the candidates for judges and prosecutors positions who are absolutely unaware of the meaning of the separation of powers and the fact that eventually they will have powers which are much, if I may say so, more stable than the powers that governments have in their terms. Sometimes it's absolutely necessary to tell them, governments change, you stay. So don't be afraid, literally, to to tell them that that's the practical consequence of the position that they're serving. Thank you.
Thank you. Professor Trujillo.
Thank you very much. I profit to say thank you for all of you also for the presentations and also for the attention, those sharing to the people online. My question is related to the four figures presented by Tanasije. The question is, did you consider every kind of judges? And the premise for this question is the distinction, and this could be a question also for some others in the session. The difference is the difference that Fuller sees between different kinds of jurisdictions, different kinds of judges, and he thinks that there is one point that is the most important point, that is the kind of decision that judges are doing. Judges in the main example of a judge is the judge that is taking a bipolar decision. It's a decision between two people or two parts. And other kinds of jurisdiction have to do with polycentric decisions. And from this point of view, I think that constitutional courts obviously are of this second kind. I will say, following Fuller, that we must do differences between the different kind of judges. Thank you.
Thank you. Nina has a question as well.
I'm sorry, but I've been suppressing my questions the whole conference in order not to hold up the schedule. So now that there's no session after this, I have to ask something. And in fact, I have a question for all the speakers, one each. I'll try to be brief. Tanasije, historical question. We know that in pre-modern times, judges used to have much more freedom. So it was relatively common in all the ancient and medieval societies for a judge to be able to fill any legal gaps with his verdict, and for that to be normal and not something to be afraid of. What do you think changed this? Was it more the absolutist rulers trying to impose their will and control the judges, or on the other hand, some progressive elements trying to limit the absolutist rulers, because if the judge could only obey written law, then the ruler could not order the judge what to do? Đorđe, more of a comment regarding the dramatis personae that you gave us here. You gave us the state, the people, and the constitutional court. I am missing, to quote Professor Patin, financial capital there. What about Rio Tinto, the company who's supposed to mine the lithium? And what about other interested parties? Because if the leader of the ecological opposition and the organization have it written on their website that they have received donations from the Rockefeller Foundation, that's not exactly just a case of the good people against the big bad company. So what about those financial factors in the picture? And the final question for Jolanta, you've given us a wide array of possible future AI legal professions, so experts who would more model something for AI to do in practice from what I got from the names and titles that you've put up. What do you think? Are those just some relatively narrowly specialized new jobs that will open in a certain number of cases but will still be a minority? Or do you think the future is for such jobs to become the majority of what lawyers in practice do? Thank you all very much.
Oh dear.
Thank you, Nina. I think that we have collected all the questions, and I propose that we start with Professor Zembrzuski. Would you like to answer your question?
Yes, of course. I hope you can hear me. Well, thank you very much. This discussion is very interesting, and I think we can discuss to the midnight. Well, I noticed one question for me from Alexa. It was very interesting and important about Protocol 16. Well, Protocol 16 to the European Convention on Human Rights shows a procedure enabling national courts to request the European Court of Human Rights to issue advisory opinions on principles relating to the interpretation of application of the rights and freedoms set out of the convention and its protocols. Well, in many countries and also in Poland, we had many doubts and questions whether the protocol was really necessary and whether it works in practice. Well, for instance, opponents claimed that it would be linked to the creation of another mechanism supporting the development of so-called judicial lawmaking, under which courts could impose new obligations. So I think that many lawyers are very skeptic. Well, the protocol entered into force, as I remember, on August 2018, after obtaining the required first 10 ratifications. And this currently in force about, please correct me, about 22 or 23 of the 46 member states of the Council of Europe. And Poland is not among them. Well, and Serbia also not, as I know. So, coming to the answer, we did something else as an EU member state, because Polish courts have asked many questions for preliminary rulings to the Court of Justice of the European Union. Many of them were connected with our situation in judiciary. It was a special way of discussion between Polish courts and European court. And as I told during my speech, the Polish authorities tried to penalize judges for preliminary questions and rulings designed to implement European standards. So, coming to the conclusion, I will express my opinion that Polish experience with the collapse of the rule of law argues for considering such a possibility in the future. Why? Because during the crisis, it could be useful for the jurisprudence. But I understand that many lawyers can be skeptic, but it is important to discuss. So, thank you very much.
Thank you, Professor Bieliauskaitė. I didn't pronounce it well this time. Sorry, Jolanta.
Thank you, Nina, for the question. Very good one, actually. I think that, okay, maybe I'm very optimistic, but as an aircraft needs a pilot, so I think the justice needs a judge and other professions, legal professions. So as far as I see recent developments, some of these professions that now are more like functions. And how I came up to this topic, because I was still, even I'm now managing the university, but I'm still a researcher in my heart. And I thought that, okay, we have to upgrade our university program of law, and what competences are future competences, how we can and what we should teach and how we should teach our students. And I came to this list of these professions. Of course, we are not teaching, and most probably you at your universities are not teaching legal design thinkers as such. And so far, I think that those professions will not be majority, but future lawyers have to have the competences to use artificial intelligence in their work, to understand the principles of design thinking, of project management, and so on and so forth. So this is my answer.
Thank you, Đorđe. Would you like to answer your questions?
Okay, thank you for your questions. First question was, and actually the second one also is related to the first. Who was the initiator? There is no data in decision who was the initiator. All interesting and important, most of the most interesting and important facts we can find in dissenting and concurring opinion, mostly in dissenting opinion of one judge. And from that dissenting opinion, but I think it's also in concurring, multinational company Rio Tinto was initiator of the process. And when it comes to Nina's question, the process of examination of regulations as well as laws in our system and in centralized system in general is abstract, and from that perspective it's not particularly important who the initiator is, because anybody can be. You might be the initiator if you wanted to be, and I want that economical perspective is legitimate, and I respect that, but I wanted to stay just on the law and constitutional law ground, not to mix it with the economical and other interests and influences. And of course, when we are on a constitutional law ground, we are dealing with that kind of pressures and interests, of course, but I try to be like neutral and to show just the legal and constitutional aspects of this case.
Thank you, and we have Tanasije. So many questions. Please just don't keep us here until midnight with answers.
So at least one more session, please. No, thank you all. Yes, of course, I will also invite for the Vilnius conference. No, I'm just joking. I'm really thankful to all of you for your very interesting inputs. I'll go by the order the questions were put. Mina, I wasn't inspired by any normativist theory when it comes to the concept of judge as a power or counter power. I really picked up concrete. I looked at the concrete situations. I looked at the judges in Poland who went into the streets to protest, to fight for their statuses. Of course, I had in mind judges in Serbia. No, I don't see that there is anything Herculean in the Dworkin sense in my idea of judge as a power. And I literally quoted, I referred to Lon Fuller. It's a very thin understanding of rule of law, as totally compared to Dworkin. So I think we should take into account these normative concepts, Dworkin, Barak, and others, Postema as well. But not at all, not the least. I really looked at the objective judges, just to give an example to show that contrary to the usual, contrary to the common wisdom that the Central and Eastern European countries and in their communist period, the judges were just bureaucrats and they were
used to seeing law as complete, perfect, and unchallengeable, and even preferring bylaws, as I said, we had in our Yugoslavia, we had for a very long period of time a huge vacuum. We didn't have the law on obligations. We got it only in 1978, and just imagine that gap, that huge gap, was filled out by judges, and they adopted good judgments. How it was the case, how was it possible? That's a topic for another conference. But the point is that when it was codified in 1978, so also the practice of the judges, together with ideas of some professors, this law stayed in power up until now with certain amendments in all former Yugoslav republics. So it shows it was a good piece of legislation. And it shows that judges in that period were actually activists, as we would say nowadays. To simplify it, I'll come back to the terminology. I see that you are looking at me, Zoran, ready to jump as if this was not enough. So that's, I really don't see heroes. Yes, to judge as a counterpower, it is something more than that. Although I have to say that when I look at the constitutions, Serbian or Polish or other cases where the judges were entering into this arena, I think that they didn't transgress what the constitution stipulates as the role of judge. So they're not entering into partisan politics. So from the perspective of the constitution, they're within their constitutional mission. They're fulfilling their societal responsibility. Whether they can pay the price for that, well, they can pay the price also for being judge as power, or they can pay the price for being judge as bureaucrat, because if they render a judgment which is against the, which is not corrupted, they're not in the favors of those who can actually remove them. So judges can be, how should I say, can be exposed in all these three figures. Of course, they're mostly exposed in the position of judge as a counterpower. Thank you for this point regarding the use of moral, regarding to the reference to moral morality. I'll take it into account, your point. Now, Zoran, where to start from? I'll start with responding to Nina. Why? Yes, because it's a very good, thank you, Nina, for your question. It's a very good point. When we look at the judiciary in the Middle Ages, for example, and the evolution from the Middle Ages of judiciary to a modern age and to nowadays, we actually see that kind of divided power. We had so many different courts in the pre-modern period, or pre-absolute state period. So this is just to tell you, Zoran, that there is nothing American in the idea of separation of powers. I mean, Montesquieu, of course, received a particular interpretation in American context, but the judiciary, and George knows that as well. I mean, a French Revolution took place exactly because the judges' parliaments refused to actually ratify the ordinances of Louis XVI, his Minister of Finances, who proposed the reforms, and they refused it. And this is the reason why Robespierre afterwards wanted judiciary to be jurisprudence to be deleted from the dictionary of French language. So I draw a conclusion that they were very powerful.
And almost brought country to the brink of bankruptcy.
So
it's an argument against judicial.
No,
Okay.
it's not. No. It's an argument against maybe politicized judiciary, which is beyond the rule of law, which is entering into the arena of politics while judging. Maybe I'm not gonna, because they had that power with the possibility of the king to come himself and to overcome. So there was that possibility as well. What we call in that language lit de justice. The king had the power to come and to overcome the decision of the parliament when the parliaments were resistant to the ratification of the ordinances. So judiciary Europe, or let me be, we are, yeah, I mean, you're very much right that we are trapped in terminology and concepts which are not inherently ours. So, and I also fight against that. I'm not, I explained that the concept of judicial restraint and judicial activism doesn't mean anything in Europe. It's a properly American terminology in the context of a constitution which is very old and which allows way more possibilities for interpretation than any modern European constitution. The same goes, and Nina, you will certainly agree with me, comes with these concepts such as modern state, absolute state, and everything. It comes from the experience of a couple of European Western countries. But there is a place then for us to try to develop our own terminology proper to our own experiences. This is why I draw attention to the fact that we had in former Yugoslavia proper judiciary in one aspect, like judges acting as power, filling out the gaps, not being afraid to legislate in the absence of legislation. So fulfilling their rule of law, their fidelity to rule of law. Zoran, 19th century parliamentarism, you know very well that in Britain it started already in the 18th century, so the history goes much before that. The balance of powers. Why I think it is important to go back to these concepts, because the separation of powers is a concept which the way that we use it today is different from the way Montesquieu also considered it, because in Montesquieu's parlance, it combines two principles of divided government and balance of powers. So why is divided government, since Polybius concept, important? Because it actually shows that each power is entrenched in has a certain social background or certain force behind it. And exactly because the judiciary doesn't have that social power, let's say background or support, we need a society to give it in the context of when it is endangered. So this is what how I read Postema's call for ethos of fidelity, that you all have to engage in this fight because it is the least dangerous branch. I mean, there is it's a common wisdom with certain exceptions, of course. I mean, and we can go into those exceptions. We are now generalizing. Yes, it's a state government. It's a government in the English meaning of that word, not in the European. I mean, in the British and American. So meaning state power. And yes, there is that kind of intrinsic contradiction. It is a governmental branch which is supposed to oversee other governmental branches, and exactly for that reason we need to be particularly protective of it, but it also has to be socially accountable. It must not isolate itself from the society, the problem of insularism of judges. They have to be responsible to the society. This is why I insisted on it. Exactly because they like the kind of discussions we had before, to remind you in the context of constitutional courts in federations, which are established to adjudicate the cases, the disputes between the federal units and federal state itself. Whereas those constitutional courts are principally appointed by that higher level federal state, and federal unions do not participate in it. So there is a kind of the concept is not developed till to its end. So there is that kind of intrinsic problem. But you see, Milica unfortunately left, but I think she made a very right point. Although they are more, if you wanted, they're more state than anyone else, exactly because they stay there. Whereas normally other political branches should change regularly. They don't feel themselves as state. So they are appointed during good behavior, whereas the others are appointed during the will of the people. The judiciary doesn't see itself, doesn't consider itself as a state power. And this is exactly why we have to...
But in Europe, that's not true. It's actually not true. They are appointed for a term and for a reason. It's kind
I'm speaking of ordinary judges, not constitutional court judges. I'm speaking of, and I've been speaking principally of ordinary judges, to be clear. So you didn't listen to me well. So if I can label you as well. Okay, so I think I will not go into other arguments that you have. No, I have actually responded to all of them, but I agree with some of your concepts. I mean, sorry, I'm a bit tired. So with some of the issues that you have raised, it's very right. We generally adopt this American or other traditions concepts, not taking into consideration the local context. Then it's yes. I mean, no, I was not. No, I was not professing for any of the models. Of course, you can imagine what I, as a citizen, think. I was just trying to help us with some heuristic tools in analyzing, and maybe in the further next step, looking for some more macro concepts and typologies of judicial cultures and legal cultures. So I started from these bricks of who are the judges, what are the judges like. I, as a citizen, of course, I have a preference for a certain type, but I'm not favoring anyone. I'm just analyzing. I'm trying to do it as much sine ira et studio. But I do agree with you that judges may become populists. However, I haven't seen them, judges, as populists, but I've seen a lot of examples of corrupted judiciary, and this case Đorđe has presented is just the best case. I mean, actually, there is we could give you some other examples from that house. So I've seen that kind of politics, not judges as populists. That you could maybe see in America. The judges are also on the state level, where in many states of United States they are elected directly by citizens. So maybe there are some cases I'm not so much familiar. I mean, not so much familiar with it. I'm familiar with it, but I've never heard. However, I can imagine that the judges are that some candidates for judges and then eventually judges are acting in a populist way in the campaigns, for example, to become judges.
Just my perception is that at least in the United States, from the very beginning, from the very election, it is known their political affiliation. So it's taken in consideration.
But they all have. They are lucky that they know what are their political considerations, whereas we don't know, and we know that all the judges have their political considerations. They all have them, but they are lucky to know what they are. Whereas because we have this myth following Montesquieu, you know, juge bouche de la loi, they are mouth speakers of the law. And we try to preserve that image of sacred sanctity of judiciary. And we, unfortunately, at law faculties, we don't speak about it. So we contribute to it by not speaking about it and by not talking of the judges as political agents. I'm not saying anything negative when I label them as political agents. I'm not saying what is wrong is when they are doing partisan politics, you know, but not when they are applying ethos of fidelity to rule of law, because they are in polis, and their judgments have political effects. So I'll not dwell more upon it, but it is clear that in this meaning, political, both judges, the bureaucrat is political, both judges' power is political, both judges. The difference is that when they do lawmaking, clearly, they refuse to admit it. They're even afraid to confirm it, although it's clearly the case of lawmaking, because they consider this to be wrong. And this is this comes from the, for example, in cases of clear ambiguities in the legislation or clear legal gaps, they have to fill it up. I mean, Swiss law on obligations clearly states. I mean, clearly states that if there is no law, if there is no contract, if there is no other source, the judge, and this is where the judge will decide the case as if he or she is the legislator. So why are we afraid to say that this is something which is legitimate? It's legal, it's constitutional. Some constitutions, I mean, some legislation provides for it, some doesn't. Stefano, yes, I mean, motivation is, I mean, the way they motivate, this is why I say that the way they argue, and this is, I would say, the most important distinction between judge as a bureaucrat and judge as a, the bureaucrat is not the best term, to be clear. There are good and bad bureaucrats, so I will, anyway, I'll think about it. They're bureaucrats in the sense that they don't feel themselves as a power, and they don't, in that sense, they don't feel the need to reason their judgment. So how are they motivated? The motivations are generally very bad. I will be very clear, not to cast, how should I say, to put in question judiciary in whole. Judgments of the Serbian Constitutional Court are very, very poorly reasoned. Each and every of them, which falls within the category of politically or economically sensitive. And I've written, I haven't written about this one, but I've written about all of them, all others. So it's, you know, black on white, and when anyone can see where my arguments come from. And I take into account the case law of the European Court of Human Rights for other jurisdictions that I'm not directly familiar with. Although I have to say that case law is not the best because it depends on what the attorneys bring. So it's not, doesn't reflect perfectly. I cannot use it entirely for my study. Yeah, Milica made a point about Judicial Academy, and I'll talk more about it with her. Isabel, yes, Vasilis, ethos of fidelity to lawyers, I think to all legal professions, we can continue thinking and adapting it. We can use this as a sort of model, as a mold, and then shape it according to the needs. Other legal professions, definitely. Isabel, yes, I took into account different types of jurisdictions: ordinary courts, specialized courts, women, men, you know, judges at the beginning of the career, judges at the end of the career. So not only me, but other colleagues, Dennis and Fioralba, with whom I did this research, we took it all into account. I would like to, you were talking about Fuller and his position on judges. I don't know that work of Fuller. If you can, not by email or now in the continuation of the discussion, that I would be very thankful to you if you could enlighten me in that sense. And that is pretty much it. Okay, so are you sure there are no more questions? I was just warming up. Okay, so I guess, Bojana, if I can take my shoes of a convener, I would like to, at the end of these two very rich days, I would like to thank you all for, first of all, your abstracts and applying, and for your presentations and for your discussions. They were all extremely enriching. I have learned so much from all of you, from the presentations and especially from the discussions. And I think we have all learned from each other. I had the feeling, I must admit, I had the feeling it will be a successful conference already when we had the abstracts. And although we had, as it is always the case with conferences, some challenges in the preparations. And talking to Professor Hasanbegović, I told her, with all these abstracts, I'm sure we're going to be walking on the clouds when the conference is over. And I have to admit that I really feel like that. So I would like to thank you all, but I would like to thank also particularly the members of the organizing committee. Alexa is now leaving the room, but Alexa Nikolić, who did not present. So you have met Aleksandar Cvetković. They were extremely devoted to, we couldn't have done it, I mean, for sure. I mean, it's with, of course, the help of our two chairwomen, Bojana and Nina, but they have done so much of that work which is invisible and without which conferences would not be possible. So we are all very much indebted to them, to Alexa and Aleksandar. I'm sorry that Alexa is not here to hear it. Alexa was very much engaged about the emails we were sending to all of you and technical preparations for the conference. Aleksandar in particular with regards to the abstracts and their formatting and book of abstracts and so on and so forth. And Bojana and Nina, you were just fabulous in all your advices in the not so much about the food. I mean, because Bojana didn't satisfy my expectation in the choice of the restaurants. I mean, that part was a bit shaky. So, but it's okay. We are learning with every conference. No, I'm just joking. Bojana was informing me of all the relevant questions, as I was not always present in Serbia while we were preparing the conference. And sorry, yeah. Yes. Yes, I mean, when I said participants, I meant all the participants and Isabel. Yeah, I think Isabel, you deserve to be singled out. You deserve to be singled out among all the online participants. So maybe a particular clap to you as well. Because this ethos of online participation really, those who respect it are very rare. However, I have to single out one person among all others, and that is Professor Hasanbegović, who is the spiritus movens. Who is the spiritus movens of this conference, and who actually gathered us all, and who wisely guided us in this process. I mean, what is most important is that this conference took place in Belgrade. And it is, of course, thanks to your engagement and the trust that the members of the International Advisory Board had when they made such a suggestion. Simply the fact that you have motivated us all, you know, to get engaged. So thank you. And last but not the least, two things related to my fellow colleague on my right-hand side, Jolanta. It is her birthday tomorrow, and we would like to also continue making friends and spending time together. We invite you as the organizing committee to gather together tomorrow at the Hotel Moskva, downtown Belgrade, Tanasije, at 10 o'clock in the morning to blow the candles with Jolanta. And in this symbolic way, pass this flame of CEENJ to Vilnius, who will organize the next conference in 2025. Thank you. The conference is over.
Thank you so much, and bye, and congratulations for Jolanta.
Thank you, Isabel.
Goodbye and see you next year.
See you.
Very much.